So we are now live.
Okay, so good evening, everyone, and welcome to the webinar on India's Digital Personal Data Protection Act 2023 and the General Data Protection Regulation of the European Union, organized by the Trade Promotion Council of India in collaboration with the Saga Legal. So before we begin, I would like to briefly introduce our co-organizers. Saga Legal is a full-service law firm with a strong national presence and growing international footprint, known for delivering commercial sound solutions across corporate, regulatory, and dispute resolution domains. Saga Legal has deep expertise in data protection, privacy, and digital compliance. The firm also helps businesses navigate frameworks like the DPDPA and GDPR, enabling secure cross-border operations. Its sectoral experience spans FMCG, digital economy, financial services, and more. So this webinar will explore how India's new DPDPA aligns with the global standards, particularly the GDPR. Legal industry and regulatory experts will discuss key similarities, sector-specific compliance challenges, and strategies to future-proof cross-border operations. So, highlighting how compliance can be viewed not as a burden but as a competitive edge in global markets. So, we will also focus on what Indian businesses must know about the DPDPA and GDPR, along with the practical strategies for readiness and compliance within India and for cross-border data transfers. For this discussion, we are joined by a distinguished panel of experts. Firstly, we have Ms. Vara Gaur. She's a partner in litigation and dispute resolution at Saga Legal, who leads the firm's technology, media, and telecom disputes vertical. Secondly, we have Ms. Priyam Dhamankar, legal and compliance professional with over 15 years of experience in the life sciences sector. She's currently leading the legal and healthcare compliance for Servier India and Sri Lanka and serves as a whole-time company secretary for Servier. And we have Varun Patil, Managing Director, CSIM India Private Limited. CSIM specializes in designing business simulations for learning and development and works with over 1,500 clients worldwide. Then we have Ms. Samona. She's the founder and director of Euro India, a consultancy that mentors companies on cross-border journeys. And lastly, we have Mr. Rakesh Maheshwari, tech policy and regulatory compliance expert with over 35 years of experience at the Ministry of Electronics and Information Technology, retiring as Senior Director and Group Coordinator, Cyber Law and Data Governance. With all that, I am pleased to invite Ms. Antra Ahuja also. She's a Principal Associate at Saga Legal to take on the role of a moderator from now on. And as a technology and data privacy lawyer, Antra advises clients on complex issues around data protection, cross-border data flows, regulatory compliance, and emerging challenges in the TMT sector. So let's welcome her and welcome everyone. So Antra, we can start.
Thank you so much, Ashima, for setting the stage. And now I believe is the time for the panel discussion where the experts unravel data privacy without a lot of jargon, hopefully. So I would like to start with the burning question that there is right now. And I would request Mr. Rakesh to maybe take this question. So we know that the DPDP has been passed, but the burning question still remains the same. What is next? And where does the law truly take effect? How will the enforcement be carried out? And with your government experience, sir, we're eager to get a clearer picture of what the implementation roadmap would look like.
So thank you, Antra, and thank you for having me here.
Thank you.
As you are aware, the Act is already out in August 2023. Right. So per se, the intent of what is expected and what is expected to be complied is already clear. The draft rules were published in January 2025. Comments have already been received by March 2025. And I'm sure in next 1 month to maybe 1.5 months, the rules should also get published. Now, beyond that, while rules will bring in maybe good amount of clarity in certain places, but once again, from from an intent perspective, expectation perspective, the stage is already set. Maybe in terms of time, it will be another maybe around 15 to 18 months before the law actually comes into force. And present IT Act, the SPDI rules are already applicable. Having said this, from the government side, the work on data protection board, the work on consent manager, and there may be onboarding of consent managers wherever, because that's an optional thing. So onboarding of consent manager, standards for the consent managers, their authorization and onboarding shall be taking place. And the board, of course, when I say board, so the recruitment of chairman, the recruitment of persons, I mean the board members, the board has to be an online board. So how exactly it shall be functioning, and the internal SOPs of the board shall also be worked out during this period. So overall, I believe from now onwards, maybe another 18 months before the law actually becomes operational.
Thank you so much, sir. That does give us an idea of, a broad timeline of as to when the law actually will be enforced. So I think that's going to be helpful for all companies and businesses to sort of already prepare for what needs to be done, because that's essentially a good amount of time we are standing from right now. Now, having spoken about the DPDPA, the most important legislation that also, a counterpart legislation that also comes to mind is the GDPR. Now, navigating data protection across borders can be complex, especially when dealing with EU, where privacy is both legal, but it's also a cultural priority. So for Indian companies, it's not just about meeting GDPR requirements, but also trying to understand the underlying expectations around data handling. Simona, you worked extensively in Germany and Czech and India. From your experience, what are the cultural and operational differences that Indian companies should keep in mind when they're dealing with EU data protection requirements? I think Simona might not be here because of her network. So I'm just going to maybe ask another panelist, Vara. I would want to know, because you are in the practice disputes and TMT and data privacy. When doing business across borders, having the right contracts in place is very essential to managing data protection responsibilities. The Indian law requires clear agreements to protect data and ensure accountability. So what, according to you, are the contractual safeguards that businesses should adopt under the DPDPA? Now, it could be like a data processing agreement or maybe audit rights.
Okay, thank you so much, Amshra, for giving me this opportunity. So, my 2 cents on this would be from real life examples. So far, what I've seen is that one, of course, the concept in itself is quite novel. So a lot of people are now just beginning to start adopting, and even for that matter, even getting sensitized enough to start implementing contractual safeguards in their day-to-day businesses. Now, having said that, what we should do ideally is, of course, streamline ourselves, in our businesses. Also, the contracts that are being, floated across in various businesses, those contracts should be aligned insofar as the provisions of the DPDPA are concerned. When we talk about those provisions, there are a couple of things which I would, point out. One interesting thing is now we know that there is a specific definition for a data principal, a data processor, a data fiduciary. We also know that the data principal has certain rights and also certain duties. We also know that the data principal has the right to for that person's data to be forgotten. So when again we are talking about contracts, in contracts, how is the data being processed? Is the data that is being dealt with accounted for? Is the consent taken for that particular data? Is the purpose of collection of that data highlighted or not? These are things which need to be sort of ensured in a data processing contract. And even otherwise, even if it is not a data processing contract per se, but it is a contract which has which mentions data processing or has something to do in relation to data processing, then these few things which are the sacrosanct as per the DPDPA or are the bare minimum as per the DPDPA ought to be mentioned. Having said that, I think one practical cue which one can do in order to ensure simplicity of contracts is to also ensure that the data which is being dealt with by a business, by any corporate, by any industry, is kept on a need basis. So any data after a certain point in time be removed or deleted. Not because this is something that we have as Indians been doing for a very long time. We tend to hoard a lot of data. But what that hoarding does in light of DPDPA is that it also lands up hoarding a lot of responsibilities and obligations for us under the Act. So in this case, for sure, the less we have, the better it is. So data minimization is important, and ensuring that you have the data for the purpose that it is required is also important.
Thank you so much for that, Vara. Thank you for highlighting the concept of data minimization, and we as Indians definitely could use more knowledge about that concept. Now, going back to the other perspective that we were going to touch upon, which is GDPR. And for global web-based companies, managing data across borders is a daily need. So under GDPR, cross-border data flows often require a case-by-case approval, and making operations, it makes operations complex and harder. So Varun, having operated in multiple countries with a global web-based program and platform, what are the biggest operational challenges that your company faces in managing global data flows under the GDPR's case-by-case approval model?
First and foremost, thank you. Thank you for giving me this opportunity. Now, it's very important to look at GDPR from an approach perspective. It's highly risk-based and highly contextual in nature, which automatically lends itself to high flexibility. But the challenge remains that it needs to be on a case-by-case basis. And for companies where a lot of day-to-day transactions are happening cross-border, it does kind of present a few complexities. So let me address three of the operational challenges which we internally face day in, day out. We're an outright software product company. Now, one part of that is that a lot of transfer of data needs to happen from EU to our India development team, primarily for bug fixes or technology improvements. Now, this is not the same as transferring data between EU countries. We've got to have a legal basis. What type of data? Do we have standard contractual clauses in place? And for that, you need to have it for all data points. So highly case by case, and what is the risk associated with that data type? The second challenge, which we kind of face every time we expand to a new EU country, is that though there is a common benchmark of GDPR across the EU, every country might pose its own complexities. For example, someone mentioned Germany in the beginning. Germany has more stringent laws on top of GDPR. So while you're expanding, you're increasing your top line as an enterprise, you're adding a lot of legal complexity to the entire equation. And last but not the least, that in India, we don't have a GDPR advocacy status. There's no parallel to GDPR at this point in time. So every time we onboard a new vendor, it might be a cloud vendor, like an AWS. We can't be working with AWS US anymore. We need to find a local entity there and go through their GDPR compliance laws. So it's a scaling problem. It's a problem when it talks about internal product development. And that's the complexities involved when we operate on practically a day-to-day basis.
Okay, thank you so much for explaining in depth what are the complexities that a platform like yours faces on a daily basis. Now, the other industry I also understand has a very, very high requirement for compliance because it deals with sensitive data is pharma. Pharma companies handle highly sensitive health data, which comes with a stricter compliance demand under the data protection laws. It's important to understand the unique challenges and the responsibilities that they face in protecting this data. So, Priyam, what additional compliance burdens do you feel that pharma companies have to take on and face given their handling of the sensitive data?
Right. Antra, you know what I feel? One way to look at it is that it is a burden, and of course that there are so many things to take care of. But if you flip the lens, it's actually a lot of operationalities, I think, which have enhanced with the coming of DPDPA. Of course, for us being a French company, GDPR was always there, and there was a little bit of, I would say, culture building around some of these aspects already. But even if you're not in the EU and it does not apply to you, I think it's more of a call for all of us lawyers to look at the operational aspects of it. Being in pharma, and because you mentioned this, I think there is a zero scope of error, probably next to aviation industry is what I would say, because the most fascinating part is for whatever we make, you just walk up to a pharmacy, you just pop it, and there is zero iota of doubt in your mind that, oh, was everything done right? Correct. So coming from a background where there is zero scope of error, I think for me, it's more of looking at these things as something which is imperative, something that has to be ingrained in the business. And yes, there are challenges, but for me, it's more about, growing the business together with understanding some of these elements. Interestingly, in 2024, there was a PwC survey which says overall, if you take a survey of Indian consumers, 82% would say that we are happy and we'll trust the brand more if we are offered data protection. I'll give you a simple example in back in our scenario as well. If we have two vendors, one who's offering us slightly higher data privacy, then definitely we will go with them, though the formalities are more. Now, coming to your question of what are some of the additional, I would say, formalities or challenges that we face. Being a pharma company, we deal a lot with patients. Digital health is something which is on the rise. There are a lot of telemedicine platforms. All of these, some way or the other, either in form of HCPs who are our customers, or patients ask for data. Kind of take the data. So I think the first step as a challenge for me was to understand how do we slot these different kinds of expectations. So for example, if it's a cloud vendor, then your encryption and breach notification related timelines is what has to be on alert. If it's a marketing partner, then you have to be very alert about profiling of doctors and explicit restrictions on how do you profile patients and doctors. There are some cases and initiatives where you even need to draw a curtain or opacity between how much of data of patients you can have access to, in some cases not at all. If it is a CRO, that is a contract regulatory organization or research organization that we are working with, then data retention and deletion is something that becomes imperative. Totally agree with what Varun said. He mentioned that it's highly contextual, and agree, because some of these examples we just saw that it's not about one answer of, okay, these are the challenges. I think with each contract, in each context, the challenges change. And that's why I'll go back to what I said at the beginning of my answer, is it's a call for us lawyers to actually understand the operational aspects of how these things work, rather than, the clauses. I'll give you an example, simple example of an audit. We were getting audited on one of our microsites, and on the microsites, we mentioned some pharmacovigilance website. This highlights why, when we speak of audits under DPDPA and GDPR, why they become important. Till that audit happened, we didn't know that the email ID is not working. And nobody knew which email ID is this, because every time the auditor sent the email, whoever claimed to be accessing that email ID never received the email. So definitely there was some glitch, and what if all of these queries and all of these PV concerns are actually being received by someone else outside, right? So I think even simple things like these can happen. And for me, the challenges are more around not just the security and spelling out in the agreement the data privacy or processing related obligations as to who does what, but actually also testing these in practice and seeing which of these are actually working in a real life scenario.
Thank you so much, Priyam, for explaining to us what are the challenges, how you navigate them. You mentioned a very interesting concept of data deletion. Now, going back to the GDPR and how data deletion works over there. Under GDPR, data collected for one purpose cannot be used for another purpose without a fresh consent. And there's no concept of deemed consent over here. So, Varun, in educational simulations like yours, how do you handle situations, say, for example, where a student asks to delete their data for, once they've enrolled with you? However, the data is also linked to important information like their progress or the certification or whatever that might be. Now, how do you ensure compliance while keeping your platform running? Now, these are two like contradictory situations that you could be faced with.
Vara mentioned, I believe that, we at India love hoarding data.
Yes.
GDPR kind of forces us to break that mindset for sure. I think we'll all agree that educational content data, student data is valuable to multiple stakeholders, right? From researchers to marketers to professors, teachers, etc. So it becomes very important, first and foremost, to define why was the data collected in the first place? What was the primary purpose of that data? And in our products, it's very simple. It's to track student performance and providing analytics to their professors / teachers on how the student learning journey is going on. So this is always what we call permitted data. So we can collect this data, keep this data for a stipulated timeline. So for us internally, we've kept that as 12 months. And after that, it becomes anonymized. The data still exists, but you can't tag it to an individual. The second kind of data, and this is where a lot of our clients also need to be educated. Our clients are educational institutes. They will send us that we want the data of the last 4 years of our students because we want to do a research. They feel that because that they were their students, they own that data, but that's not necessarily the case because that was not the original intent. And suddenly you need consent from each and every individual student for that data to be shared. In the world of AI, and this is where we again come back to the term contextual, case by case, student performance data. Why can't I use that to improve my AI algorithms and provide a better service to the professor for better analytics? But again, this is a case by case where even to improve our own algorithms, you can't use that data unless and until you have explicit consent from the participants. So this is where, first and foremost, being a technology company, you need to have some technical controls. Every data which is introduced on a platform is first and foremost tagged at the backend. What are the allowed uses of this data? Before that tagging happens, there is an entire process control committee, which kind of has folks from within the organization, and we have lawyers working with us who tell us why of it primarily. So both the technical and the process control is the mechanism through which we kind of ensure that we are always following practically all guidelines. But it does become operationally complex because some countries in the EU have their own rules over and above that. So for example, I can send a marketing email to a student who's currently playing our game. But the moment I talk about Germany, Germany will dictate you can't even send a marketing email. Now, sorry, let me just clarify. When I say I can send a marketing email to a student using my simulation, It's to do with content based on the simulation they're playing, the game they're playing, the product they're using. Nothing about that. So there are complexities, there are operational challenges, but as we all agree, it's kind of beneficial for the organization and more importantly, beneficial for the end users that these things are in place.
Absolutely. Thank you so much, Varun. And what brings me back to the Indian law is how India is also sort of putting and posing penalties if data compliance is not done properly. So whilst companies face a lot of issues operationally, and they're somewhat used to the GDPR mechanism if they have been dealing with companies that adopt the GDPR, in India, DPDPA is relatively new. So what we hear about penalties is like there are huge penalties that have been brought in with the DPDPA. So with strict penalties and liabilities for non-compliances, understanding that these consequences is crucial for business to avoid costly fines and reputational damage. But more importantly, companies also need to know how to manage these risks effectively. So, Vara, what are the penalties and liabilities under each regime, specifically the DPDPA, and how can businesses mitigate these?
Thanks, Amshra, for that question. So, so the penalties per se have been explicitly stated in Schedule 1 of the DPDPA as it is today. And they go all the way up to 250 CR. Under Section 15, if there's a penalty in light of violation of Section 15, it's 10,000, and then the next penalty starts from 50 CR and goes up all the way to 250 CR. But this is one thing, and this is still something which has been demarcated. But how I see penalties, especially for businesses, as a lawyer who advises a lot of businesses from on day-to-day basis, is that once you are talking about data, and let's say, for instance, let's take an example of a med tech app, a health tech app. If there is that kind of data, let's say 200 patients patients who are coming in, patients who are going out, how much of the purchases have been made inside the pharmacy of the hospital, that data, what kind of ailments those patients have, what is the age of that particular patient, what is the gender of that patient, all of these things form a data set for which consent is required. If that is not taken, if there is a penalty imposed, if somebody goes to the Data Protection Board of India, lodges a complaint, there is this is obviously subsequent to everything coming into force, but let's say that happens and a penalty is imposed, it is not just the penalty, but the reputational damage is going to be so catastrophic because it will remove, like for a pharma company or a health tech company, it will be, an avalanche of stress, to say the least. The moment, this kind of turbulence happens, even if a fine of 15,000 is imposed on a pharma company, their reputation goes for a toss. Now, again, if I take an example of an edtech platform where, a lot of times you have to take approvals from the parents of the child, especially under the DPDPA, it's a minor who is concerned. So the consent, so to speak, is the consent of the parents and not per se of the child. Again, if you've not taken parental consent, what is the penalty which will come to you? There is one thing that you will be, imposed X or Y penalty. But apart from that, the business loss, which is going to come to that particular business, is going to be insane. It'll be multiple, and it'll go up notches and notches. So this is what, I feel that businesses need to first understand in order to mitigate penalties and in order to avoid these kind of instances in the first place. One thing that businesses now need to do, and for a lot of companies like the pharma and all, they're already sensitized, they're already, and cross-border transactions, wherever there are cross-border transactions, there also, people are already sensitized, so they know. But in India, domestically, companies first need to be sensitized enough to know that this is beyond what is stated in Schedule 1 of the DPDPA. This is not just going to be a 50 CR or a 100 CR game. It's going to affect you in years to come. So, the one thing is that you become sensitized, then you ensure that you have all the, infrastructure legally, you have sound contracts, you have policies, you have data minimization, data deletion policies, you have checks technologically that, consent is taken from the right person, things like that. And that is when a business can be said to, move in a direction of being able to defend themselves or mitigate penalties, to put it like that. Yeah.
Vara, you raise a very important point, which is that a lot of the industries that are dealing with highly sensitive data are already sensitized to these legislations, whether it be the GDPR, whether it be the DPDPA. Even before it's enforced, a lot of these industries are sort of sensitized. However, when it comes to smaller institutions, companies, and maybe startups, those are the kind of setups that are not sensitized to this. And I think when they, as non-sensitized companies or startups, read something like, a penalty of say 100 crores or 200 crores, that's when it hits hard. Which is why we also, as lawyers, in our endeavor, try to sensitize these smaller startups, smaller companies, so that they take that action and are not essentially scared of, the penalties that are to be imposed under the legislation, but are ready for it.
I feel, to add to it, I would say they should not just be scared, they should be preparing much ahead of its implementation, because eventually everyone's going to be running pillar to post the moment things go into action. So, lucky are those who have already been complying with GDPR norms, because they already have that culture around them. But it's going to be a tough situation for domestic players to, start implementing it. These are things which generally, are very low on the priority list for them. But yeah, the way they have fixed the costs of penalties, the intent seems to be that they want all the companies to pay attention, and that this is important and this needs to be addressed.
And like Rakesh also mentioned, that there is an enough, a big timeline that has already been given to companies. It's still not enforced, and I believe even once it's enforced, a certain buffer period will be provided to the company, and I think they should make the most of it. Having said that, Data Protection Board under the DPDPA will play a key role in overseeing and enforcing these data protection laws. Now, understanding how it will function and engage with businesses is essential for companies preparing for compliance. So, Rakesh sir, would you shed some light on how the Data Protection Board will function and interact with businesses?
So Data Protection Board has a simple function as far as, I'll say, enforcement of maybe any non-compliance of the act is concerned. Like in GDPR, you have the suo motu powers. In India, in DPDPA Act, there is no such suo motu power available. Hence, the major task of enforcing the law continues to be with the central government, who is competent to come up with the rules, maybe come up with any guidance, if at all they are issued by the government in future. The board will not really have that kind of a role, but the board is going to, in fact, any data principal can approach the board for what they feel is the non-compliance to the act, maybe either in terms of the consents which have been taken, or maybe the data which, the way the data was agreed to have been processed, is not being processed. Parallelly, of course, the companies also have the obligation, and that's where it is very, very important, that the companies do not just have the obligations to report any data breach. So the law, unfortunately, does not provide sort of a baseline. It says any data breach, personal data breach, needs to be reported to the board, and not just to the board, but also to the affected data principals. So per se, from a board perspective, it is much simpler. From an organizational perspective, from a data fiduciary perspective, it's important that they create a system of knowing today, knowing that as to when and what exactly the breach is, when exactly it happens, and thereafter they have a very short timeline of reporting it to the individuals, to the people who have been impacted or likely to have been impacted. In fact, to get to know as to what is the level of breach. I mean, many a time you don't even know for months together. So fortunately, there is a caveat there. But if you have become aware, you need to immediately analyze, inform the board, and maybe come up again to the board within 72 hours with whatever details that you have. And for that reason, you also have to have the security in place. From the board perspective, naturally, they have the because once again, as has been mentioned by fellow panelists, it's a cultural issue. So as of today, even the board members, whoever comes, and given the size of the country, the number of breaches that we have even today being reported, I mean, the large breaches that we know, almost large breaches which happen in India every month, the workload, if not really managed, is going to be humongous. For each of the case which is reported either by the data principal or by the company, a good amount of investigation also needs to be done to be able to adjudicate the level of penalties. Not because, I mean, penalties have been so cast in black and white. After all, I mean, they also need to be judiciously determined. And enough of opportunities need to be given to the data judiciary. Maybe a review is also possible. And of course, the data protection board is indirectly accountable because there is a tribunal or maybe higher judiciary which comes into picture. Yeah, that's it. That's it from
Thank
my
you,
side.
sir. Thank you for explaining how the data protection board. Thank you, sir.
Yeah.
Thank you for explaining how the data protection board will interact with businesses, how it will function, what its functions are. Now, we also understand that many industries today rely on global partnerships. So, DPDP is one aspect of it, and then there's GDPR, and there's other laws in other countries. So, with different data protection laws, like the ones that we are speaking of today, staying compliant across borders can be a real challenge. Now, the question is, Priya, how does your industry specifically navigate global partnerships while complying with both GDPR and DPDPA?
Frankly, Antra, to that effect, if I focus on this, then I think majority of this chunk of transactions will go to what is really booming in India currently today, which is global capacity centers for pharma, especially, right? And India is being treated as the hub of all these centers, though the regulatory data protection, is a bit of a contested issue. But I think that is one of the huge chunk of transactions that I see where many of these things we'll see how they shape once certain elements of DPDPA get triggered. But I think apart from that, Antara, most of the work that I see we do is a mix of the work that we do with global partners as well as local partners. And that's why I think the readiness of local partners is something that actually comes up as a question we have to ask ourselves when it comes to getting ourselves ready. Another aspect is now because GDPR is already in place and DPDPA is already there. Our organizations back in global, which have evolved in their journey in GDPR, have already put in place a lot of matrices, a lot of questionnaires, a lot of checklists, due diligence items when it comes to evaluating parties, third parties or vendors that we would work with. So one challenge that comes in, especially working not more so global, but more with local vendors, is they have a product which you can really use. They have an interface which you can really use as a platform, because in India, when we speak about, we always divide the country in metros, tier 2, tier 3, right? And the patient reach and the doctor reach is in all parts. And all sophisticated platforms will not work everywhere. So sometimes you have a very local solution, but how to get this past muster the test of what is already in place in terms of standard, as a gold standard now to say, in terms of data privacy is a challenge, which I see a lot while working on some of these projects. I think for us as an organization, and globally also maybe, another challenge which I see is first identifying the SPOC. Who's the SPOC? Who understands this in the first place, right? So, of course, you can read the clause, you can read the law, and you can explain in legal terms, this is how it will happen. But then an operational stakeholder working with you cross-border may or may not understand the technicalities of it. So, how do you educate or get a SPOC ready who understand the legal requirements, at the same time also understands what does it mean operationally? I'll give you a simple example. We were implementing SAP, and SAP is the most widely used ERP today. But with the DPDPA, simple query coming from the SAP implementation team as to where does the data sit? Does it sit here on the server? Does it go back to global? Is Paris going to have an access to it? Is it going to be a real-time access? I think it was a big journey to get ready or to come to that position also. And the third challenge, I think, more than working externally with parties is more of internal, is to how do you loop all of these things with the SPOC? And mind you, even today, as we speak of DPDPA, data privacy SPOCs are still IT people and not lawyers, right? We are going slowly to that stage where we see things need to change. But that collaboration along with IT, along with your global colleagues, especially speaking in context of cross-border, is, I think, a journey which we are working on, but I think it's going to still take some time to get both the ecosystems ready for each other so that everything becomes more like a straitjacket formula, at least in terms of basic expectations that the business partners have from each other.
Right. Thank you so much, Priyam. We understand how difficult it is to sort of, get these two legislations, the SPOCs from the legislations, to identify them, to sort of have some coherence when we're dealing with this. I think this is a problem that a lot of businesses will be dealing with, and implementation, especially with the DPDPA, will become clearer as the law is enforced and brought into practice. And once it's brought into practices, Vara, what I suspect is that there will be some dispute or a lot of dispute. Now, I wanted to understand what kind of disputes do you suspect could crop up once the DPDPA is enforced?
So, Antra, first of all, like Mr. Rakesh had pointed out very rightfully, anybody who's a data principal can go. And, and if they feel that their data has not been used in the manner that it was supposed to be used in, they can approach the Data Protection Board of India. And above the Data Protection Board of India, there's also TDSAT. So all the appeals would go to TDSAT. Now, the kind of disputes that can arise, okay, they may be disputes which would stem from an individual complaining that their data has been misappropriated, or there may also be in situations where an individual's data, or rather, I also see a bunch of individuals, like a class action where their data has been collectively shared with third-party vendors, and in that case, the primary data fiduciary may not even know how to address that particular issue, because third-party vendors have, let's say, had unauthorized access to the data which was being used. Okay. And in that situation, and that is not even an Indian player, let's say that person is situated somewhere outside of India, there'll be those kind of disputes where, and especially now, see, people who are actually sensitized and people who are aware about this, they will, in all likelihood, approach, and they would want to, protect their data rights. But and therefore they'll come and they will raise these questions. The question which beckons is that how will the dispute eventually get resolved, because it's going to be so permeable insofar as nationalities are concerned, and so permeable even at the level of various industries. Let's say a e-commerce website which is being storing all sort of customer data, the name of the person, the address of that person, the location of that particular person, and there is a instance where their data has been accessed by a third party vendor online. So all that data, all those addresses, all those names, everything goes to a third party vendor, and that e-commerce website does not even know about it. Now where does the liability lie? The data principal had given their data to the third part, not to the third party vendor, but to the e-commerce website. So they will come and they will implement the e-commerce website as a party. They will probably allege that you did not comply with the DPDPA, you did not have the requisite infrastructure to safeguard my data, which is why this particular situation has arisen in the first place. They'll also have to seek, John Doe orders against third-party vendors because they don't know who the third-party vendor is. So how will they implement that particular, how will they reinforce their rights is something which we will see as courts grapple with various disputes as the DPBI and the TDSAT eventually deal with.
And
Thank you so much.
can I add something to what Vara said,
Yes,
just a
please.
little bit on a
Yes.
lighter note? And Vara, excellent, I think excellently put. One of the disputes that I really see, which we didn't talk about, is the disputes that we as lawyers and in-house people are going to face on negotiating each contract once this come in,
Yes.
and which is a fight, especially coming from a very in-house mindset, is arguing those small audit related clauses, small bickering around retention or liability and indemnity. How
Yeah.
are we going to really trace back the vicariousness? Like, we're talking about spelling out the roles of each and every party. This is the in the contract. But if one of those parties fails, then how much of vicariousness is going to be attributed in practice when this dispute escalates to all the parties? Because the name gets dragged anyway, right? If one of the parties
Correct.
and Vara was mentioning some time back about the reputation, which is a very key point. So if your processor fails, there is no escape to the brand or the organization to say, oh yes, but we did everything all right. They were the ones who kind of messed up, right? So I think these are the softer parts of the disputes which are going to creep in more and more when we start enforcing some of these terms more vigorously.
Yes.
Thank you so much, Priyam. Thank you so much, Shara. It's always very interesting to understand how, after the enforcement of a law, it's going to play out. There's a lot of prediction around what kind of disputes, what kind of resolution will happen. So, I mean, getting that from experts like Vara and Priyam is always a welcome and a great opportunity. Even for businesses to be able to kind of foresee and navigate it. Having said that, sir, Rakesh, sir, I will ask you one more question because I am personally very interested to understand this. Now, while we know that the DPDPA is obviously here, but what is the government's perspective on data protection in the age of AI and large-scale automation?
So this is something which is evolving, number one. But from the DPDP Act perspective, it has beautifully carved out that something which has been posted by you on a public platform, and hence something which is publicly available, either because you have shared it or there was a legal obligation to share it, can actually be scraped by any AI platform or maybe by any other platform. So a beautiful carve out therefore has been made. I mean, maybe unfortunately, maybe I have posted something about me, fine, but I have posted something about somebody else. Now, has somebody else given the right one to post I mean, to be posted by me, maybe on a personal basis, yes, it was okay. But when it goes into the AI, I'll say system, or maybe into everybody, I mean, with everybody, probably that consent was never expected to have been given. And this is one area where, for example, ANI versus OpenAI issue is tussle is already on. So this is one area which will evolve over a period of time. Maybe US has already given the hint very clearly that in the interests of being a superpower in the AI area as well, for the time being, forget about some content creators, or maybe something which is publicly available must completely be used to train the AI systems. I believe in the interest of having good AI systems, particularly in the context of Indian languages, that exemption, though already given, but with whatever vagueness that you have, let this be continued here in India as well. That's it.
Thank you so much, sir. I find this space completely fascinating. So I thought I'm going to take up this question with you. But I think that brings me to an end of the questions I may want to ask the panelists, so that I can open the floor for any questions that our audiences might have. So in case our audiences have any questions, please feel free to shoot the questions. Ashna, will you be able to look at the questions, right?
Yeah, currently I don't think we have any questions. If there are any questions, we can take them offline, if that is okay. Yeah.
Okay, sure. So I think the feature is not enabled. That's perfectly okay. But I think any concluding remarks from any of the panelists are welcome.
No, I think just to draw on Vara's point, which she mentioned, and that's really, I'm picking this point up because it really resonates with what we do as a pharma company each day. Is more and more this area becoming an area of competitive advantage. Looking at it right now from a very compliance and regulatory perspective, but the way we see is for example, for me, where I come from, you design an entire program, something like a patient access program for the patients, but they don't trust that they can upload their documents with the basic privacy and protection that they seek. Then the entire program collapses, right? So I think more and more the narrative around be it GDPR or DPDPA needs to be set around how it can be more of a competitive advantage, and how it will become more and more a foundation of loyalty or trust, which definitely is the currency that works in business.
Thank you so much for that.
Okay, so we have, sorry to interrupt you, Antara. We have some questions from the audience. So first, we have, what's the impact on an exporter of automotive parts?
I think Ashna, hello.
Hello. Yeah, am I audible?
Hello.
Yeah.
Yeah, Ashna, I see the questions. So we did end up receiving a couple of questions from the audiences. And one of the questions that there is that can an organization rely on consent obtained under the IT Act, or does DPDP require fresh consent collection and updated privacy notices? So if any of our panelists would want to take up that question, feel free.
So, Antra, I'll chime in there.
Hello.
So, insofar as that particular question is concerned, see, under the IT Act, the consent that was, and by the way, the IT Act also defines data, but under the IT Act, the consent that used to be taken was on a very different context. And over here, because, the security of data and, data as a commodity is being spoken of under the DPDPA. So it always practically makes sense to have fresh consents and fresh notices so that you are, in harmony with the provisions of the law, which is going to be very soon implemented.
Thank you so much, Shara. We hear you. A fresh consent is always great, especially considering that DPDPA is going to be enforced. So in tandem with that. So we do have another, I think we have time only for, we've gotten about a couple of questions, but I think we have time only for maybe another one. The other question that we can take is that what is the key difference between data protection vis-a-vis government entity and private entity? Maybe Rakesh sir would be happy to take that question, or anybody else.
Yeah, so with respect to the government, maybe while it is one of the biggest data fiduciary in most of the scenarios, the fact remains that they have to function, they have to do the obligations which have been casted under the law, various laws, provide the services to the citizens, maybe certifications, maybe authorizations, maybe licenses. So the law has already carved out certain legitimate, I'll say, scenarios where no consent per se is required. So government is majorly covered in that particular category. However, having said that, I still believe that the government also has to have, or government departments will also have to have a privacy policy clearly communicating as to what and why they are collecting, with whom are they sharing. So obligations remain.
Okay.
Of course, there are certain agencies who shall be completely exempt, but there are also a bit of role for the law enforcement agencies, which do collect. Am I audible?
Yes.
Yes.
Yeah. So there are sorry, it appears maybe my connection is not all that good. Should I go ahead?
Yes, you're audible.
Yeah. So with respect to law enforcement agencies, also something similar will have to be worked out by them, that whatever they have collected or whatever has been provided voluntarily by the citizen. So these are the two buckets which they have to, in a way, treat separately, and maybe they do not have a direct obligation to report as a breach, but all other obligations of maybe maintaining the security of this data. And in case the data principal approaches, particularly when the voluntary data had been given on a voluntary basis, I mean, they are equally, government departments will be equally liable under the law. So as of today, under the IT Act, the liability as of today is zero legally. But under the DPDP Act, the government will also be liable, may not require the kind of consents the private organizations will need, but still the security, as well as maybe in some cases, even reporting of the breach, not in all cases, reporting of the breach will also have to be undertaken by the government departments.
Thank you so much, sir, for answering that question. And I think we had time for only that last question. This does bring us to the end of this webinar. And today we've learned a lot amongst, the importance of clear contracts for data compliance, the challenges in managing data flows under GDPR, under DPDPA, the roadmap ahead for India's DPDPA enforcement. So I would like to give a huge shout out for our amazing panelists who are our real life data superheroes. Thank you so much for being with us. Thank you so much for educating all of us. And whether you're watching live with us right now or you're watching at your own time, thank you to the audience for being with us. If you have any further questions or maybe want to just dive deeper, please feel free to reach out to any of us or the panelists. Thank you, everybody.
Yeah, thank you very much.
Thank you,
Thank you,
everyone.
Andra.
Thank you very much. All the best.
Thank you, my co-panelists also. Thank you.
Thank you to TPCI and Saga to come together and collaborate and have this webinar. Hopefully, looking forward to a lot more of these collaborations.
Thank you, Andra. Thank you.
Thank you.
Thank you, Ashwini.
Bye-bye.